Ready, start. By letters dated 3rd September, 2014, the appellant submitted separate claims concerning the three ROBs for damages on account of the delay on the part of the respondent. Full stop. By letters dated 14th October, 2014, the respondent rejected the claims. Full stop. The appellant applied for further extension of time by letters dated 8th January, 2015. Full stop. In response, the respondent addressed a letter dated 9th January, 2015 by which the appellant was called upon to give undertakings to the effect that the appellant will not claim anything extra other than escalation for the work executed. Full stop. The appellant submitted undertakings on 14th January, 2015 accordingly. Full stop. The appellant invoked the arbitration clause on 25th January 2017. Full stop. The appellant filed a statement making a claim for rupees 44.11 crores under 15 substantive heads besides the claim of interest and costs. Full stop. The respondent filed its statement of defense. Full stop. The respondent filed an application under section 16 within bracket 2 of the Arbitration Act. Full stop. It was contended in the said application that clause 49.5 of the general conditions of contract disentitles the appellant from raising any claim for damages or compensation for failure or delay caused by the respondent in fulfilling its obligations under the contract. Full stop. The arbitral tribunal passed the order in the respondent's application under section 16 of the Arbitration Act in nature of an award dated 21st December, 2019 by which all claims were rejected based on clause 49.5 of GCC. Full stop. Aggrieved by the impugned award dated 21st December 2019, the appellant preferred a petition under section 34 of the Arbitration Act. Full stop. The learned single judge of the High Court of Delhi dismissed the petition, holding that a term like clause 49.5 of the GCC would bar the appellant's claim. Full stop. Moreover, the appellant had accepted the communication dated 14th October 2014, issued by the respondent dismissing the claim. Full stop. It was also held that clause 49.5 was valid and, after the appellant accepted the same, it could not contend to the contrary. Full stop. Being aggrieved by the judgment of the learned single judge, the appellant preferred an appeal before the division bench of the High Court of Delhi by invoking section 37 of the Arbitration Act. Full stop. While dismissing the appeal, the division bench held that the requirement of clause 49.5 was never waived by the respondent. Full stop. The division bench held that clause 49.5 was a valid clause. Full stop. After holding that the powers of the court while dealing with an appeal under section 37 of the Arbitration Act are limited by section 34, the division bench dismissed the appeal. Full stop. The learned counsel appearing for the appellant has made detailed submissions. Full stop. His first submission is that the award of the arbitral tribunal was contrary to public policy and suffered from patent illegality. Full stop. The learned counsel also pointed out that the main issue was whether a clause prohibiting the payment of damages, like clause 49.5, could be enforced. Full stop. He submitted that the arbitral tribunal and the learned single judge failed to appreciate the crucial aspects striking at the root of the award. Full stop. The learned counsel pointed out various decisions of the Delhi High Court and this court. Full stop. After relying upon several decisions of this court, he urged that the parties to the contract cannot contract against the Indian Contract Act, 1872. Full stop. He submitted that the finding recorded by the arbitral tribunal that clause 49.5 aims to protect the interests of PSUs and the government is illegal. Full stop. He relied upon the decision of this court in the case of Palm Developments Private Limited versus State of West Bengal. Full stop. The learned counsel submitted that the additional documents filed by the appellant ought to be considered. Full stop.